Good evening. Welcome to Florida Cannabis Action Network. Talk it out. My name is Jody James, and I get to be the president this year of this amazing 28-year-old organization. If you're new to Florida Cannabis Action Network, welcome. We are again, 28-year-old organization. We are dedicated to giving voice to the voiceless. For many years, that meant talking for the plant that couldn't talk for itself. Today, it includes working with consumers, working with the Florida legislature, creating advocacy campaigns, doing a lot of public education, and, well, basically doing whatever we can do to change the laws. Florida Cannabis Action Network recognized, in the very beginning, that there were three ways to change the laws. Of course, you can change the law through the legislature, you can change the law through the Constitution, or you can change the law through the courts. And with our third branch, which of course the third branch of government being the courts, we like to look at ways that citizens can impact what's happening with the courts. So today it's Thursday, March 26th. We're actually waiting for tomorrow morning when some local Tampa citizens are going to be talking about a lawsuit against Hillsborough County and Hillsborough Sheriff's Department. So, that's one advocate who has decided that the way they were treated by law enforcement just didn't work for them. And I know I've heard a lot of people say, wow, it seems like we're living in a police state. And wow, it seems like we're going backwards with prohibition, not forward. People are very concerned about their liberty, about how we're going to get to the point where we can actually have access to this plant as individuals, and how we can protect other rights while we're exercising our constitutionally protected state legal medicine. So one of the things that we do with our third branch is examine the ways that individuals can make an impact. You may have seen Vera Cooper and Nicole Poole and Neil Franklin. They're three Florida Cannabis Action Network members who are currently in court fighting for their Second Amendment rights. And somebody has to coordinate all this action for Florida Cannabis Action Network. And that's Benny Blanchard, the head of our third branch, and Steve Thaw, our co-chair, communications guy, and video expert. Benny Blanchard came to us several years ago. Benny and I were sitting around in a group, and he was telling me about some of the actions he was taking and some of the things he was learning as a pro se litigant. Benny's not a lawyer. And I remember thinking, wow, when the story of the last free man in America is written, I'm going to have a bit part in Benny Blanchard's life. So I believe that we are talking about liberty. I believe we're talking about freedom. And I believe we're talking about the way that we can give you back your American dream. So Benny Blanchard comes to us again, pro se. He's not an attorney. Nothing that we say today is to be construed as legal advice. This is education and entertainment. And Steve, I hear in the background that you're going to be monitoring us on Facebook. So if you're watching tonight and you have some questions, please relay it in the chat. Steve can let us know, and we'll be asking questions. Steve, say thank you or say hello, and I'll say thank you.
Hey everybody, I'm Steve out in Jacksonville, Florida, and sorry about that coming on the mic. I forgot to push the mute button before I logged into Facebook. It happens. And as you said, I'm the creative chair now, and I'm trying to come up with creative ways to get our message out to everybody. I'm here with Benny Blanchard. He does the real work. He takes the cases to court and does all sorts of pro se litigant stuff. I tried to keep up with him, and this guy he doesn't stop. He just keeps writing, and I don't know where he finds all the time. So I'm going to go ahead. I'm going to turn it over to him. I'm going to let him introduce himself.
Hi, everybody. Thank you very much for coming and watching us tonight. I've been a pro se litigant for 3 years now, and my focus has been on cannabis, property taxes. It's also been on Americans with Disabilities Act lawsuits, in which I'm trying to make it better for people who are deaf and all sorts of First Amendment activities. So tonight I wanted to show you guys a lot of the research and the reading that I've spent doing in order to learn and understand why we have to fight the courts the way we do. So I'm going to share my screen with you guys for a presentation. And ooh, so what we have today is ownership versus use and possession of cannabis for the police powers and the Commerce Clause. Now, these are going to be new terms for many of you. Write them down, save them. Well, you can do some research later on. It's going to be very useful for you to have an understanding of this. First, the general disclaimer. This presentation is under the First Amendment right to associate and discuss laws and judicial opinions with our peers and members. It doesn't replace qualified attorney for consultation, and is for educational purposes only. So our goals are, what do our Article 1, Section 2 rights in Florida protect? What does ownership, possession, and use mean? And what do SCOTUS rulings and recent discussions that regulate power, police power, and Commerce Clause do in this situation? So have any of you in Florida gone to our Florida Constitution and read Section 2 about our basic rights? It reads, all natural persons, female and male alike, are equal before the law and have inalienable rights, among which are the right to enjoy and defend life and liberty, to pursue happiness, to be rewarded for industry, and to acquire, possess, and protect property. Now, ownership doesn't appear here because of the way we construe our laws for possession. You can acquire things, then you possess it depending on its use. Now, the thing I want everybody to look at is inalienable. We started with inalienable rights back in 1700s. Then the states, prior to the 14th Amendment, protected our rights. But after the 14th Amendment, it shifted to a federal focus in protecting our rights. And there were interesting consequences for this. So right now, the way I read my law here, the constitutional right, is I have the liberty to acquire cannabis, possess it, protect it in order to enjoy life, pursue happiness, while I'm rewarded for industry.
Hey, Benny, I want to jump in here real quick and ask a question, because this is what I have thought in my mind is, I personally, sure, I have the liberty to acquire cannabis and possess it and all that because I have a medical card. But if I don't have a medical card, what gives me that right, that liberty to acquire cannabis if the government says it's against the law?
Go ahead, Jody.
Well, I think that, Steve, you're asking the question backwards. And that's, if I have an inalienable right, what gives the government the authority to tell me I can't? And that's always been my question. When I was talking about inalienable rights and taught about inalienable rights, someone said, no, 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 those are the ones that you take with you, that you get because you're human, right? That simply they should be yours. I'm not quite sure about the acquire, possess, and protect property, and how, I don't know where use came in. So you've almost lost me at the jump. Benny, can you help me with the use idea?
Yes, so use is what you do with property. So Mugler versus Kansas was the Supreme Court decision that decided this, and it was actually in our last video, so I want you guys to go back to that to reference it more later. However, oh no, I lost my train of thought. Anyways, going back to use, you can own a piece of land but the way the state or your local county has regulated its use is what stops a Walmart from building in a residential neighborhood. It regulates how that property has its privileges, if you will. This is administrative in a sense, so that goes to police power, which we're going to discuss later on. Now, possession is 9/10 of the law. Think about it. You can own property, but someone else can possess it. You can have a rental car. You can rent a home. You can possess Federal Reserve notes. They belong to the federal government, but we use them because they're meant for our commercial transactions, our private debts, all of these things. These are all just very interesting bundles of rights that goes with property, and they have different types of bundles per property. So this is where you get in, this is where it really gets divided into different levels of subcategories. That this is where lawyers specialize, like insurance, contract, all of these things. So that's why they have to know their specific bundle of rights per subject that they have. So all of this goes back to the police power and the Commerce Clause. One of my favorite recent Supreme Court decisions is the Bruin decision, where they say you must take the Second Amendment from the historical standpoint. So I've started gathering cases and whatnot that go to property rights and cannabis rights as far back as I could go. And one of these is our natural rights verbatim in Article 2. The right of acquiring, possession, and protecting property is natural, inherent, and unalienable. It is a right not ex gratia from the legislature, but ex debito from the Constitution. So going back to what Jody said, the Constitution says you have these rights. We need to stand on our constitutional rights because they are historically protected. All of our rights come as far back as the Magna Carta. So that's very, very important to think. We have British rights that came, that was called common law, that has been slowly recharacterized by our own decisions as the new updated common law. Now, the most recent property rights or personal rights distinction comes from Lynch Household Finance Court. Property doesn't have rights. People have rights. The right to enjoy property without unlawful deprivation is in truth a personal right. And in fact, the fundamental interdependence exists between the personal right to liberty and the personal right in property. Does that sort of answer your question, Steve? Does that give you a foundation to work from?
It does. And you know what? I love the way that Jody put it, because being in the Navy, I'm just used to, or formerly being in the Navy, I'm sorry. I'm just used to rules applying to everything. And I don't think from a standpoint of, well, what tells me that I can't do that? I've always thought about it of, okay, they tell me I can't do it. I can't do it because that's the way the military is. So, Jody, thank you for opening my eyes to that kind of a perspective. And I couldn't agree with you more. And that clears stuff up a lot for me too.
Well, I think it's important, one of the things that when FLCAN was young, right, 20 something years ago, part of what we were trying to do was help people get out of the brainwashing that we got from just say no, right? So just say no. It wasn't ever a good reason on why you should say no. It wasn't even it's really bad. It's just say no. How simplistic. And then they layered on, well, it's bad, it's bad, it's bad, it's bad. So just say no and it's bad. And it doesn't matter that they weren't telling the truth about it being bad. So we spent an awful lot of time in the early days trying to help people understand that they'd been lied to about cannabis, that there really were benefits to it, and that most of what people knew about cannabis was myths. And, we still fight that today. And I think part of what you're talking about, that just, well, it's illegal and someone said it was illegal, so that's good enough for me. That's that same idea. It's illegal, it's bad, nothing I can do about it. But thank you, Benny. There is something we can do about it. And I want to encourage people to go back And maybe Steve, when we're done here today, you can go ahead and put a link. I know that last video that we did with Benny is already on YouTube, and someone could go back and take a look at that. And if you're just tuning in, we are getting into some common law. We're doing a little bit of discussion on police powers. Benny is talking to us about some of the cases that see, I want to be in the inalienable rights store. It looks like a much better line. But of course, I'm always the, cut the line option kind of girl. Benny, I'll turn it back over to you. Let's talk about our
That,
fabulous
that
inalienable
is where it
rights.
comes back to why have we lost our inalienable rights and why are we stuck in privileges for using things? So when we have our police powers from the state, which comes from Mugler versus Kansas, because you have the privilege of doing business as a commercial zoning or industrial or renting property as residential, those are privileges that can be regulated under the administrative estate. So that is all the rules and the regulations and the policies and whatnot. So think of that. That is something that we can challenge in Florida because administrative agencies get de novo review over their decisions. De novo means a new review. So if you don't like what you got from the agency, you can take it to court and get a fresh, brand new perspective. Recently, that has been done federally as well when they overturned the Chevron deference in Loper Bright versus Raimundo. Those are also great decisions that you should go read, and they explain why they dismantled the administrative estate, if you will, and they started going back to a constitutional legislative intent. So this case, everybody knows this is the Obamacare decision, where the Supreme Court struck down the requirement for Obamacare to be a tax for everybody. It's National Federation of Independent Businesses versus Sibelius. Google this, put this in there, just start reading it. I've taken pages apart and tried to pick out the best parts of it for you.
And Sibelius was the attorney general at the time. Who was a Sibelius?
No, I believe he was the director of health or something.
Director of Health. Okay, very good. Thank you very much for clarifying that.
This was a
And
case where like 15 states signed on and sued the Department of Health's requirement for this, including Florida. And there were at least a dozen amicus curiae, which are supporting briefs from other organizations to help them decide what to do. So in this opinion, it describes our federal system. The national government possesses only limited powers. The states and the people retain the remainder. Nearly 2 centuries ago, Chief Justice Marshall observed the question respecting the extent of the powers actually granted to the federal government is perpetually arising and will probably continue to arise as long as our systems shall exist. And this is in McCulloch versus Maryland, one of our earliest decisions. Go read these. You should have as you become a legal scholar, you're going to start collecting these opinions. And you'll begin to understand why lawyers or justices refer to these decisions when they want to give people the foundation from where they are working from. In this case, we must again determine whether the Constitution grants Congress powers it now asserts, but which many states and individuals believe it does not possess. Resolving this controversy requires us to examine both the limit of the government's power and our own limited role in policing these boundaries. So in this case, they're trying to tiptoe around all 3 branches of government's prospective rights. The federal government is acknowledged by all to be one of the enumerated powers. Abed means the opinion they referenced to before. That is, rather than granting the general authority to perform all the conceivable functions of government, the Constitution lists or enumerates the federal government's powers. Congress may, for example, coin money, establish post offices, raise and support armies. The enumeration of powers is also a limitation of powers because the enumeration presupposes something not enumerated. This is something we need to start exploiting from a historical perspective. What are these unenumerated rights? Because, quite frankly, they try to avoid describing them. The Constitution's express conferral of powers makes it clear that it does not grant others, and the federal government can only exercise the powers granted to it. Indeed, the Constitution did not initially include a Bill of Rights, at least partly because the framers felt the enumeration of powers sufficed to restrain the government. In other words, they were so worried about how little we separated these powers, that they tacked on even more rights for us. So that is why we have so many amendments to our Constitution. And that's why we can change our Constitution slowly. We still have this power today, it's just not used anymore. Just think about how we banned alcohol. Now, the famous, as Alexander Hamilton put it, the Constitution itself, in every rational sense and every purpose, a Bill of Rights, in references to the Federalist Papers. Please do go read that, but it's going to be a very dry read, and you're going to need to take this in small chunks. When the Bill of Rights was ratified, it made express what the enumeration of powers necessarily implied. The powers not delegated to the United States by the Constitution are reserved to the states respectively or to the people. And that was the 10th Amendment. The federal government has expanded dramatically over the past 2 centuries, but it still must show a constitutional grant of power that authorizes each of its actions. Put your mic on, Jody.
Thank you. And we've been here just long enough for the cottonmouth to kick in. But I wanted to ask, so okay, the 14th Amendment is getting ready to come in here, and I get that that's important here somehow. But where did they get the power to schedule drugs? It's certainly not in, the Big Ten. It's not in the Bill of Rights. It's not raising money for an army. It's not coining. And then that added my second question. How does the schedule of a drug give it authority over me as a citizen of the United States? If I don't want to trade in it. So, Steve started this with, he has the right to have and possess cannabis because he's a medical marijuana patient and he's qualifying under the medical marijuana program. We all agree that certain things should be inalienable rights, and the Constitution grants us inalienable rights. You've just told us that the power of government is supposed to be limited to these enumerated powers. And
Because of the clause.
What's that?
Because of the Commerce Clause, the federal government has the right to regulate intra-state commerce and all things that may affect it. And that goes to a decision called Wickard versus Filibert, which is the wheat decision. Which I think pretty sure we covered that one too in the last one, so you can check the link below as well.
We did.
But this is why I say we need to learn our stare decisis, our previous decisions, because we understand the interlocking chain they're building each decision on. It's almost a blockchain. Federal law is basically a blockchain in a sense that everything is built off the foundation of the previous precedent, and you literally have to overrule a whole bunch of it before you can alter the course of how that opinion is going to be used below. So what we were talking about before was the federal power. Now, the same does not apply to the states because the Constitution is not the source of their power. The Constitution may restrict state governments, as it does, for example, by forbidding them to deny any person the equal protection of the laws. There's your 14th Amendment. But where do such prohibitions do not apply, state governments do not need constitutional authorization to act. The state can thus perform and do many of the vital functions of modern government, punishing street crime, running public schools, and zoning property for development, to name but a few, even though the Constitution's text does not authorize any government to do so. Our cases refer to this general power of governing possessed by the states but not by the federal government as the police power. See United States versus Morrison. So that is where we separate federal power and police power, but now we're going to take it a step further by going back to federal power and looking at the Commerce Clause. This is going to be me when I die. The people cremating me. Yo, do you guys smell weed? So go back to the police power. Because the police power is controlled by 50 different states instead of, oh, I want to go back to one thing on this. Equal protection. This kind of struck my head. DC allows people to grow 6 plants. Why does DC have this ability to do it, and I don't have this equal protection? So there's a little loophole if people want to go down that rabbit hole, so to speak.
Danny, there have been people for the last 25 years that the federal government has sent weed to in great big tins. I have a picture out there someplace in the social media universe. I have a man standing next to me that he's got his tin of 300 marijuana cigarettes, and there's a woman standing next to me and she's got her tin of 300 marijuana cigarettes, and I have a little sign with a pot leaf that says, "What about me?" So I'm totally in. I think that's a great point. Why can you grow 6 plants in Washington, D.C., but not in Melbourne, Florida?
I think there's a lot of us that want to know that, Jody.
On in the most recent. Oh, Steve, go ahead.
Oh, I was just saying, I think there's a lot of us that want to know about that. I know I'm included in that. Why can't I grow my own either? I just don't understand.
The territorial aspect of that is actually being argued over in a decision now with the birthright. So you can sort of go down that rabbit hole there. Now, back to the police power is controlled by 50 different states instead of one national sovereign. The facets of governing that touch on citizens' daily lives are normally administered by smaller governments closer to the governed. So that's why you have state, and then in Florida, it's home rule, which gives that more local rule and control to the local governments. So that's where the counties get to delineate what they want to do with their use of property, what kind of conservation grants, who gets to go where. That is the example of the local police power that is subject to the legislature's instructions. The framers thus ensured that the powers in which the ordinary course of affairs concerning the lives, liberties, and properties of the people were held by governments more local and more accountable than a distant federal bureaucracy. The Federalist No. 45. The independent power of the states also serves as a check on the power of the federal government by denying any one government complete jurisdiction over all the concerns of public life. Federalism protects the liberty of the individual from arbitrary power. Bond versus United States. So you guys gotta go read, and read, and you're gonna start understanding this little strange web we've woven for ourselves. Now, this case concerns 2 powers that the Constitution does grant the federal government, but which must be read carefully to avoid creating a general federal authority akin to the police power. That's why I took the time to read and explain everything before to give us the foundation for the case. The Constitution authorizes Congress to regulate commerce in foreign nations and amongst the several states and with Indian tribes. So the Controlled Act is Mike Kravitz's pigeon, where he's gone through the treaties for that. That is why we have the Commerce Clause affecting us with our foreign nations and the several states. Our precedents read that to mean that Congress may regulate the channels of interstate commerce, persons or things in interstate commerce, and those activities that substantially affect interstate commerce. So that is why all the little stuff that happens with the use of cannabis as medical marijuana is affected. The power over activities that substantially affect interstate commerce can be expansive. It has been held to authorize federal regulations of such seemingly local matters as a farmer's decision to grow wheat for himself and his livestock, and a loan shark's extortionate collections from a neighborhood butcher shop. See Wickard versus Philibert. But what people don't realize is when you read the finer details of Wickard, he had taken a loan from the government. And so, because his actions were subsidized to bring something to the market, the government has every right to regulate what they subsidize. So, Wickard again also has a narrow loophole we haven't exploited yet. It's regulating somebody who intended to be in commerce and interact with the public in general, or doesn't have or has a license. So those are all things to think about. That is regulatable. The individual mandate, however, does not regulate existing commercial activity. It instead compels individuals to become active in commerce by purchasing a product on the ground that their failure to do so affects interstate commerce. So think about what that's really saying for a minute, because if we can't be compelled to buy something for a regulatory purpose, why can you compel me if I'm not only growing just for me? And we have a statutory right to do so here in Florida under 6471.845 or something like that, something in that general area. And that's in the agricultural. Again, we have our state-protected local government rights. We're not using enough within our statutory loopholes. Again, has the same thing for the Commerce Clause. If we can't be compelled to buy something, then why are we being controlled? How does the Controlled Substance Act apply to us? And again, this is all theoretical, hypothetical, just questioning. I'm not saying go out there and show the cop that we don't have to follow the Controlled Substance Act anymore. That's that. No, don't blame me for that.
Well, and the further disclaimer, if this is something that you're interested in doing, this is exactly the kind of case that changes the world. There are people, one of the first videos that I ever did that kind of got a little bit of play, I didn't even realize I was making a video. We were standing outside the DEA agency in Tampa, Florida, and we had just been told that if we didn't disperse from what we thought was pure First Amendment activity, that someone was going to be arrested. And so I gave this little lecture, hey, if you are interested in committing an act of civil disobedience today, we are considering, and you would be willing to continue to protest here in front of the DEA on a public sidewalk. We believe that you're within your First Amendment rights to do so. But if you're going to do this, don't complicate it. Gave him a little lecture about making sure somebody else had their car keys and somebody else was watering the dog or watering the plants or picking up or had bail money. Never bail money because you'll get out the next day. But, that kind of thing. So there is a place for civil disobedience. So to say to somebody, oh, don't go do this. Well, don't go do this because we said so. But if you believe that you do have an inalienable right to this and it's something that you're interested in, this is the kind of thing that we work together to make sure that you have the perfect facts, and move forward from there. I was thinking about this as you were talking, Benny, and you said, Wicker, he had a loan. And so Wicker's loan brought him into commerce. I have a mortgage. So my mortgage is sort of subsidized someplace somewhere, because it's a guaranteed loan. Okay.
On that later, I know exactly where you're going with this, and this is why I confirmed the other cases.
We're not wrong, but don't tell people not to do this if they want to. Just tell them to call us first.
Exactly. So this instead compels people to become active in commerce by purchasing a product on the ground that their failure to do so affects interstate commerce. Construing the Commerce Clause to permit Congress to regulate individuals precisely because they are doing nothing would open a new and potentially vast domain to congressional authority. Everyday individuals do not do an infinite number of things. In some cases, they decide not to do something, in others, they simply fail to do it. Allowing Congress to justify federal regulation by pointing to the effect of inaction on commerce would bring countless of decisions on an individual and could potentially make within the scope of federal regulation and under the government's theory, empower Congress to make those decisions for him. So you have a clear stand from the Supreme Court saying you can't make decisions for us, but we need to take that further. The government repeats the phrase active in the market for healthcare throughout its brief, but that concept has no constitutional significance. An individual.
Hang on, Benny. We've been at this a minute. For people who are just tuning in, give us the citation. What case are you referring to right this minute? So people can go back.
Let me see here. Hold on, I'll find it for you.
Thank
This
you.
case
Just
is
real quick.
National Federation of Independent Businesses versus Sebelius, who was the Director of Health for the Department of Health.
And it's all related from Obama, it would also be considered the Obamacare decision in case someone wants to back up. Fabulous. You're getting to the good stuff.
Awesome. An individual who bought a car 2 years ago and may buy another in the future is not active in the car market in any pertinent sense. The phrase active in the market cannot obscure the fact that most of those regulated by the individual mandate are not currently engaged in any commercial activity involving healthcare, and that fact is fatal to the government's effort to regulate the uninsured as a class. Our precedents recognize Congress's power to regulate a class of activities. See Gonzalez versus Raich. That's our famous medical marijuana license case. So again, all of these create a foundation for which you to follow what this decision is saying, but you have to spend time building your literary foundation. We have never permitted Congress to anticipate the activity itself in order to regulate individuals not currently engaged in commerce. Each one of our cases, included those cited by Justice Ginsburg, involved pre-existing economic activity: orchid, wheat, rape, super, growing marijuana. So we're already in our sphere with our discussion, and we're just bringing it far more into the cannabis sphere for ourselves. The opportunity is here. It's up to us to bring these cases there. Everyone will likely participate in markets for food, clothing, transportation, shelter, or energy that does not authorize Congress to direct them to purchase particular products in those or other markets today, unless it's a hurricane or something. The Commerce Clause is not a general license to regulate an individual from cradle to grave simply because he will predictably engage in particular transactions. Any police power to regulate individuals as such, as opposed to their activities, remains vested in the states. So I almost wonder, does the Controlled Substance Act actually violate the spirit of the police powers? There's ways to look at it, there's ways to argue it, but we'll get there. Don't smoke too much, you have to go to work. A minute later, raisins are great jerky. So I'm going to keep going on this. We're almost done with this decision. The government relies primarily on our decision in Gonzalez versus Raich. At Raich, we considered comprehensive legislation to regulate the interstate market in marijuana. Certain individuals sought an exemption from the regulation on the ground that they engaged in only intrastate possession and consumption. Intrastate means you only buy and sell within the state entirely. It does not cross state lines.
And Angel Reich, she was interested only in cultivating her own cannabis for her own use. So this was 100% about And I will say that she was also a patient under Proposition 215 in California. So she had the legal right to be part of a dispensing organization, but at that point she did not have the legal right to cultivate for herself.
Because she had a license, and only because she had a license. That's in my opinion, at least. Certain individuals sought an exemption from the regulation on the ground that they engaged in blah, 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 that. We denied any exemption on the ground that marijuana is a fungible commodity so that any marijuana could be readily diverted into the interstate market. Congress's attempt to regulate the interstate market for marijuana would have thereby have been substantially undercut if it could not also regulate the intrastate of possession and consumption. So this is the Supreme Court drawing a fine line on that, but they didn't address that what's outside of the license. So again, I think that's our loophole because this whole decision is about compelling us into interstate commerce. But if we're not having a license and we're not engaged in commerce, where do we stand historically? Go ahead, Steve.
So for those of us who may not be familiar with this case, what are the quick down and dirty facts of it?
Of the Obamacare decision.
No, the Gonzalez versus Raich, where she was trying to grow her own marijuana.
Yeah, she was trying to grow her own marijuana, but she had a medical marijuana license from the government. So that created a subsidized because corporations only exist at the whim of the state government. They can be dismantled by the state government at any time, not so much at the federal government because of a certain decision. I won't get into that. So that is, again, that decision still only talks about a regulatory sphere. The ones we want to exploit are the private inalienable rights that we started with historically before the Marijuana Tax Act and before the Controlled Substance Act.
So interestingly enough, when Governor DeSantis signed his very first bill into law as the governor of the great state of Florida, he signed into law the right of Floridians to have whole flower. That was the first bill he signed, right? So that's what took us from the point where you had flour in the little ceramic jars with the metal lids in it that fit into your vaporizer. You had gummies and you had tinctures and we had vapes. But in order to get whole flower, that was like a lawsuit that our past president, Kathy Jordan, was involved in. John Morgan backed it. They had this great constitutional attorney who argued it. And the way that that case was decided was a bill was passed that opened up the market for flour. At a press conference, the governor, who was at Harvard at the time of Reich, was asked about people being able to grow their own marijuana. And the governor brought up Reich versus or Gonzalez versus Reich and said that he believed it had been wrongly decided. So I was probably one of 7 people in the whole flippin' universe that was watching that press conference that knew what the Reich case was, but Angel Reich was a friend of mine. And so I had known her for 15 years before Reich was settled. And it was fascinating that our governor believed that the court was wrong. He believed that Reich growing her own marijuana for her own use wasn't commerce, what wouldn't impact interstate commerce. So question here, Benny, based upon the new case law, are we thinking that it might be time to relitigate some of these issues?
Absolutely, absolutely. There's always new case law opening up, and that is something we'll get into after this, because all of what we're doing here pertains to the canons of construction, which is what I'm going to take advantage of for trying to get horizontal to open back up. But it still affects how we read our case law. So
All
I'm
right,
just going to finish
thanks.
this last part of this Obamacare decision. Accordingly, we recognize that Congress was acting well within its authority under the necessary and proper clause, even though its regulation instead some purely intrastate activity. Rights thus did not involve any great exercise of substantive and independent power. Instead, it concerned only the constitutionally of individual applications of a concededly valid statutory scheme, going back to the license. So that's where I want you guys to think about. There's always loopholes. Now, this is the other decision where we touch on your concern about the mortgages. Jones versus United States is actually about a canons of construction case where it tells the courts to start looking at how words are used more. And this is my favorite three-letter word again, use. In this one, because an owner-occupied residence not used for any commercial purpose does not qualify as property used in commerce or commerce-affecting activity, arson of such a dwelling is not subject to federal prosecution under Statute 844I. So if this is saying an owner-occupied residence is not used, what's the other side of that? What does it mean when it's not used in commerce like wicked? The key word, let's see here. The government relies principally on the breadth of the statutory term affecting commerce, words that, when unqualified, signal Congress's intent to invoke its full Commerce Clause authority. But 844 contains the qualifying words used in a commerce-affecting activity. The key word is used. Congress did not define the crime as explosion of a building whose damage or destruction might affect interstate commerce, but required that the damaged or destroyed property itself had been used in commerce or an activity affecting commerce. The proper inquiry, therefore, is into the function of the building itself, and then to whether that function affects interstate commerce. So, active for employment for commercial purposes and not merely a passive, passing, or past connection to commerce. It is surely not the common perception that a private owner-occupied residence is used in the activity of receiving natural gas, a mortgage, or an insurance policy. So this is a very, very specific carve-out that, again, puts us outside of the Commerce Clause. So if we're not engaged in an activity that has a connection to commerce, does the wicked decision apply? So Jones has left us with some very interesting things, and this was before Obamacare.
And Jones was 2020 or what year was Jones?
It was 2002.
And
2000.
Reich, 2000. And Reich was
Let's see.
99 maybe?
Which was 5299. I'm looking for, I'm hoping to find where it's first.
Yeah, sorry about that. I was just trying to remember. I could look it up.
No, that's okay. We have just enough time to do it. Versus Rage. Nope, not in here, unfortunately. I think Gonzalez
Okay, well, let me
versus
look it
Rage
up.
at the same time.
It seems to me as well. But we have new stuff, and I like the new stuff. Tell us more about the new stuff, because this is fascinating.
So the new historical standard, the New York State Rifleist Pistol Association versus Bruin. Once the Second Amendment text covers an individual's conduct, the government bears the burden of demonstrating that its restriction is consistent with the nation's historical tradition of firearm regulation. Now, if we have inalienable rights, what are those historically, and does that include controlling my right to grow marijuana and for my own private consumption? Because, again, touching back on the previous YouTube video, we discussed the dissident of Mungler versus Kansas, saying that we have every right to grow what we need for our own substance, our own medication, our own stuff. And that is a historical intent as far back as right after the 14th Amendment. So That's why rereading all of the historical cases now brings new ammo for us to fight. So this is a great time. Now, when I smoke a joint, this is usually what happens to me. I love nature so much. What a beautiful day. And then you get down to that last little fifth of it, and it's the raccoons work for the CIA. There's always something going on.
It's the squirrels, not the raccoons, man. The squirrel threat level is elevated.
Okay. I first want to give a huge shout out to our brother and sister organization, NORML, the National Organization for the Reform of Marijuana Laws, did a recent amicus curiae in the recent U.S. versus Himami case that absolutely broke this down in a way that is better than I can. I highly suggest that you go to the Supreme Court's website and look up number 24-1234. That's amazing. I have the same combination on my suitcase. So read the case itself and the amicus. And also the oral argument is fabulous, where they got to duke it out very recently. The transcript for that is also on the Supreme Court's website. So the Second Amendment protects the right of the people to bear arms, U.S. Constitutional Amendment 2. Cannabis users are plainly amongst the people to be afforded its protection. They are not aliens, enemy combatants, or some constitutionally excluded caste. They are ordinary citizens and residents, many of whom are veterans, workers, parents, and medical patients who happen to also consume a plant that Congress still places in Schedule 1, but partially protects and promotes an interstate commerce by means of spending appropriations measures. So there's another little hidden backdoor that we're dealing with here when it comes to regulating cannabis as well as guns. Historically, and this is taken from the amicus, by the way, historically going back 400 years, cannabis in and of itself has not been viewed as a harmful plant or threat. Only since the 1930s and beyond, with a Schedule 1 designation under the Controlled Substances Act of 1970, has it been so regulated, which has been acknowledged for political reasons. To wit, John Earl Richmond, White House counsel and chief domestic advisor to Richard Nixon. Whatever else might be said about federal drug policy in the 20th century, it is historically impossible to claim that cannabis use is a new societal problem of the sort Bruin treats differently. Cannabis was familiar to the founders and widely used in various forms well into the Reconstruction era. If the framers of the Reconstruction Congress believed that cannabis use justified disarmament, they had many opportunities to do so. They did not. I know, I agree, Steve. Bravo. Significant federal restrictions on cannabis are a relatively modern development. Congress first imposed the comprehensive federal controls through the Marijuana Tax Act of 1937, which made it prohibitive to grow commercially. We were still not regulated then for private grow. In other words, where I argue Wickard had its loophole. Both were enacted long after the founding and Reconstruction eras. Statutes of such recent vintage cannot retroactively supply the historical tradition required to justify a firearms restriction. Now, if you go and read it more, they broke it down into other subsections. Why cannabis is not heroin. They talk about how the drunk laws of the 1970s and early 1800s and early 1900s were for people who were so drunk they were rolling around in the mud with the pigs. They could not function in society. That was the purpose of the disarmament or restriction laws back then. Cannabis users don't roll around drunk in the mud. We don't pick bar fights. We start a band. And that's kind of sort of what we need to be arguing before the courts in the historical sense is, do we have such a restriction right from the federal government at the modern federal and state policy? So we have clear carve-outs between the right to grow from the inalienable rights perspective, and then from the statutory regulatory scheme, which is privileges. Think about driving. Driving is a privilege because we're using the public roads in a fashion that needs to be safely regulated. So that is where privilege comes into play. So go find that amicus. Again, bravo, Norma, bravo. You summed up so many things that I've been thinking about in one unique document, and I hope people who read this can take it into the future for us. That's pretty much all of our presentation for today. So I'm going to give you two a chance to ask me any questions that may condense this whole thing into one summarization that helps you understand.
Steve, any thoughts?
Actually, Betty, this time around, I feel like I understand it better than the way that you explained it the last time around. Like, I actually am coming out of this with no questions, surprisingly. Which for me, if you don't know me, I always have a ton of questions. So for me to not have a question, that's pretty I'm pretty happy with the way you did that. That's awesome, Benny.
I'm just so overwhelmed. I can't think of a question. Same thing, only different, right? If we were gonna say, because obviously we can leave that the Supreme Court has changed its opinion. I am looking at this through the lens of, okay, can we move to a point where my grow was protected? Now, I went back and did a little bit of history on Reich, and she was cultivating 6 plants, which was legal in California, but it was the feds that were involved in busting her. And so she was saying that she had the right to cultivate. They were saying she didn't have the right to cultivate. So, and yet DC's cultivating 6 plants. It's fascinating where we've ended up on, huh? If you were going to set up the perfect situation, you're telling me that having a mortgage isn't significant based upon Jones. So just because I have a mortgage on my house doesn't make me involved in commerce or getting a subsidy from the government that it would exclude my right to cultivate for my own personal use.
It
So
depends on the statutory scheme. So obviously, Steve has this Section X constitutionally guaranteed medical marijuana rights. Those do not apply to the Article 1, Section 2, because that falls within a regulatory scheme that the state created out of the use of the cannabis plant, either as hemp or medical marijuana.
So the ideal plaintiff would not be someone who has a medical marijuana card. It would be someone who does not have a medical marijuana.
They don't have a
We're
medical
talking about
marijuana card. Your house should be paid off. That is my
no
suggestion, just to make
mortgage.
it simpler for you. Um, if anything, have it agriculturally zoned. Number four, have a great relationship with your neighbors. Now, because you must also understand your nuance laws, because if you've been farming for a year, they can't exactly bust you for smells. So there's all sorts of little interesting things to come into play here. But however, one plant is all you need. We want to keep this as the lowest, simplest, because again, how do they even know it's not hemp, which is an entirely different crime in itself, statutorily, depending on when and how it tests out. Oh, then we're supposed to have mandamuses done by the Department of Health or the Department of Agriculture for people who are growing without a license. So there's all sorts of little very interesting angles, loopholes, and ways to look at this and affirmative defenses to raise in order to combat this. But simply put, own it, don't have a business on the property, and even if it's like me, I have a massage business in a private office shed. Does that qualify? Because my residence is entirely enclosed and separated. Would that trigger use, especially when there's loopholes in the laws for that? These are never-ending things you do. We should be having debates over this rather than which Marvel Avenger is stronger.
Well, and for those of you who stuck with it, we're going to wrap up now. This is Jody James and Steve Thaw. We have been happy to moderate Benny Blanchard's discussion today on police powers and the Commerce Clause. Certainly, this is kind of one of those talk it out. We know that this is pretty heady stuff and not for everyone, but it certainly is the way that we move forward using the courts. This affirmative defense is really how we have accomplished an awful lot of things over the last 50 and 100 years. That's the idea. When we first went to court in April of, oh my goodness, what was it, 2013 now, with Kathy Jordan over growing her own plants, we were using an affirmative defense. We believed that she qualified for what was known as the medical necessity defense, which was an affirmative defense. Now, not every judge will allow you to present an affirmative defense, which is how a lot of these cases end up in higher courts. So this is not something to enter into lightly. But if it is something that you're considering, if you have your own property, if you are not already part of the medical marijuana program, if you are zoned agriculturally and don't have commerce on, it's not a working farm or something like that, and this is something that you are considering.
Zoning shouldn't matter, but we'll go from down from the agriculture, just makes it a little bit safer for you.
Just want to make it safer for you. If it is something you're considering and you're feeling really empowered to put seeds in the ground, put seeds in the ground. In Florida, under Governor DeSantis, he also signed the right to garden, which says you have a right to grow herbs, food, and vegetables on your property. So while the Controlled Substance Act is certainly governs commerce, we have to take a pause on whether or not it governs you as an individual. You have liberty, you have inalienable rights, you are the star of your own show. And if putting plants in the ground is what you believe is right for you and you have legal issues with that, please don't hesitate to reach out to Florida Cannabis Action Network. If you can set yourself up to be safe, like by owning your own property, not having other commerce, being zoned agriculturally, and not being part of the medical system, those are certainly things that would make the case a little bit smoother. Should you have an encounter with law enforcement, they are going to take your plants, and that's when you're going to have to decide whether you're going to capitulate or you're going to present an active and affirmative defense. Florida Cannabis Action Network is with you, and we thank you very much for being with us. You guys have a great night. Thank you very much, Benny. Thank you, Steve, and we'll look forward to talking to all of you again soon. Thanks for watching.